Welcome, everyone. Thank you for listening to the Council of Institutional Investors Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. Our topic for this episode is a recent research paper entitled Texas, Delaware, and the New Controller Primacy. And our special guest is the author of that paper, Christine Hurt, Senior Associate Dean for Academic Affairs and the Alan R. Bromberg Centennial Chair in Corporate Partnership, Business, and Securities Law, and a professor of law at the Southern Methodist University Dedman School of Law. Welcome, Professor. Thanks for taking the time to speak with us today.
Well, thanks for having me, and I apologize for having such a long and laborious title.
No problem. Professor, explain to our listeners what you mean by the phrase new controller primacy, and what was your motivation to author a research paper on that topic?
Thanks for asking. I think most of your listeners will be aware that for the past 50 years, Delaware law has been described as director primacy. Sometimes it's been sugar-coated as shareholder primacy, but what that really meant was that you had a board of directors that was working for the best interests of the corporation and the shareholders as owners of that corporation. Right? And Delaware corporate law assumed this paradigm where you had a board of directors that's managing the corporation with a C-suite of professional managers, and that ownership of the shares of the corporation were widely dispersed. And in that scenario, it probably is best for the board of directors to be given a lot of discretion and presumed to be acting in the corporation's best interest. So that's how we get the business judgment rule and 102b7, and we want to incentivize these kind of professional managers to take risks. However, today's so-called Delaware crisis seems to be the result of a new paradigm in publicly held corporations, where through a combination of the prevalence of dual-class stock, companies not going public for a long time because of the abundance of private financing pre-IPO, we have large publicly held companies that are headed by a controlling shareholder, and that controlling shareholder is also sometimes the CEO. And they've picked the board, and they really call the shots, and a lot of people believe that the welfare of that corporation depends on making this controlling shareholder / founder happy. And Delaware law has never presumed that these participants, these controllers, were acting in the best interest of the corporation. And so there's a lot of doctrines that create exceptions. These cases that are brought by shareholders, these derivative suits, saying that controllers are not acting in the best interest of the corporation, those cases get a little bit further, right? And so they don't all get dismissed at motion to dismiss or motion for summary judgment. And so corporations have been upset because what they really want is not director primacy anymore. They want controller primacy, where one person who may or may not be a genius, who may or may not know what's best for the corporation, really gets to do what they do best, and the courts let them do that.
So following on your comments on the new controller primacy, many believe recent efforts by Delaware, Nevada, and Texas to amend their corporate law statutes to attract new incorporations and reincorporations is a so-called race to the bottom that harms long-term shareholders. So can you speak about that? Are they wrong in assuming that? And can you explain your views on this notion of this race to the bottom?
Sure. And also, just to segue, I think you had asked me why this is interesting to me. All of this is interesting to me because I am a Texas lawyer. I've been a law professor since 1998, but I've always maintained my Texas bar card. I love Texas. I guess I have to say that first as a disclaimer. I love Texas. It's a wonderful place to live. We have great schools. We have great weather. So that's what got me interested in this paper, was that I saw a lot of people who knew an awful lot about Delaware law and an awful lot about Nevada law talking about Texas law. And if you remember last summer in May of 2024, Tesla filed proxy materials because they wanted the shareholders to vote to reincorporate in Texas. And they did not describe it as a race to the bottom. They described it as a race to the very top because Texas had this great corporate law, and it would help Tesla to continue its journey to make its founder's vision possible. And knowing a lot about Texas corporate law, I thought, really? Really? Is that what Texas corporate law does? Because Texas does not have a huge body of corporate law. There are only about 70-ish publicly held corporations that are incorporated in Texas. So we don't have a lot of cases on these doctrines that you associate with derivative lawsuits of publicly held corporations. So Tesla definitely didn't think that Texas was going to be a race to the bottom and presented it as a race to this really stable and certain corporate law, which did not ring true to me as much as I love Texas. So now, of course, we've had Delaware tinkering with Section 144 and Texas passing a big mega bill about corporate law. And so the question of, are Texas, Delaware, and Nevada trying to compete to be the lowest liability state, right, is one way to put it, where managers don't have to worry about liability. First of all, I think the question hinges on whether or not you think that fiduciary duty litigation is a dead weight loss on the corporation, right? Whether you believe that it just drains the corporate treasury and there's no benefit to shareholders or to the corporation. If you believe that, then you would think the lowest liability state is a race to the top, right? Because you'll be keeping more of your corporate surplus and you won't have these silly, frivolous lawsuits to deal with. If you think that there needs to be a balance between shareholder derivative suits and not wasting money on frivolous litigation, I think Delaware is still your choice, right? I think Delaware has tried to strike this right balance for decades, and Nevada has gone farther than that. I think you probably don't fear shareholder litigation as much in Nevada, just for various reasons. And now Texas has completely created a brand new bottom. And I hate to say that because, again, I love Texas, but we have this new legislation that says that you cannot bring a derivative suit against your corporation that you own shares in if they have put in their governing documents, which may just be the bylaws, that you can't unless you own a threshold percentage of the shares outstanding. Tesla, the very next day, amended their bylaws and said you cannot bring a shareholder derivative suit against us unless you own 3% of the outstanding shares, which would cost you on that day about $31 billion. So Texas, if the corporation chooses to make that election, has basically become a no liability state for those corporations.
So I think I know the answer to my next question, but let me ask it anyway. So let's assume I'm a long-term institutional investor of a U.S. company that is pursuing an initial public offering, and I will have the opportunity to influence the selection of the jurisdiction in which the company will be incorporated. So if my three choices are Delaware, Nevada, and Texas, please explain how and why I, as a long-term investor, would rank those three choices from most shareholder friendly to least shareholder friendly.
I don't think that any of those states would advertise themselves as being shareholder friendly. So we're talking about relative shareholder friendliness among them. So if you were looking for a shareholder friendly jurisdiction, you might go to a different jurisdiction. But between those three, again, I do think that Delaware is the most balanced, right? And I don't think people liked it when the vice chancellors were saying, listen, if we're going to have a credible system, sometimes plaintiffs win. Like every decade or so, a plaintiff gets to win. If you think that plaintiffs should never win, then you might head on down to Texas. I also think that if I'm a long-term buy and hold institutional investor, then I like certainty. Uncertainty also costs a lot of money. If litigation costs money, then uncertainty in litigation costs even more money. In Texas, I just don't see the certainty there because there haven't been any cases. There are bound to be challenges to some of these statutes. You don't know how these statutes are going to be interpreted. In Delaware, even though there's been a lot of talk about how uncertain the cases are, there's a lot of certainty in Delaware. If you want to achieve a certain result, then there is a way to get there. Although I think some commentators would argue that It's hard to know who's going to be independent, even if you create an independent committee. It's hard to know if the controller is letting go of the process, even though it looks to you like they're letting go of the process. But in Texas, we don't even know. Like, we've never had any kind of experiments on the process or on how the definition of independence is interpreted.
Professor, your paper notes that 16 states have adopted the Model Business Corporation Act, Section 2.02B4, which allows a corporation to limit liability for directors for breaches of duty. That provision is similar to Section 102B7 of Delaware General Corporation Law, except that the Model Business Corporation Act provision lists a smaller set of exceptions to director exculpation that is currently permitted under Delaware General Corporation Law. So those 16 states that you reference in your paper are Alabama, Arizona, Colorado, Hawaii, Idaho, Iowa, Maine, Michigan, Mississippi, Montana, Nebraska, South Dakota, Utah, Vermont, Washington, and Wyoming. Your paper also calls out 2 additional states, Indiana and Ohio, as having less shareholder-friendly business judgment rules and/or standards of review than Delaware currently has. So if I'm a long-term institutional investor and I'm voting on a reincorporation from Delaware to one of the 18 states discussed in your paper, should I consider voting against the reincorporation because it would weaken shareholder rights?
I will say that since the passage of the Texas bill in May, Texas has codified its business judgment rule, so it is also very shareholder friendly. The presumptions are pretty strong, and you can only overcome them with a showing of fraud or intentional violations of the law, misconduct. So the difference between the NBCA exculpation clause and the 102B7 exculpation clause really hinges on what I would call sort of low-level breaches of the duty of loyalty, right? So nothing that implicates the duty of loyalty can be exculpated in Delaware, although you can waive usurpation of business opportunities. For the NBCA, those sort of low-level breaches of the duty of loyalty, such as the duty of oversight, can be exculpated. So a lot of this is sort of how many angels can dance on the head of a pin, because in Delaware, you can't exculpate for the duty of oversight, but directors rarely lose on that, right? It's very, very hard for plaintiffs to adequately plead, much less prove, a breach of the duty of oversight. So part of the uproar came from the Bluebell case, right, which overcame a motion to dismiss where people died. There was very little compliance. And then Boeing, where, of course, people died as well. But that ignores the hundreds of cases that had gone before where plaintiffs can't adequately plead that cause of action. So to me, that's the main difference between the NBCA and the 102B7 is, how long of a fight would you have for a duty of oversight claim? And there are so few of those and so few are successful. I don't know if it would be worth it to reincorporate just for that.
Professor, your paper includes a discussion about the importance of the definition of an independent person for purposes of the survival of a shareholder claim or a particular person's individual liability. Which jurisdictions, in your opinion, have the most and least shareholder-friendly definitions of independence for directors of their corporate boards?
So I did not do a 50-state survey as to whether or not which states had a statutory definition or which states had a common law definition. If I were to guess, most states have not dealt with this issue very often. Again, it is something that comes up if you have shareholder derivative suits and if you have a big board, like a board of a publicly held corporation, right? So Delaware has a lot of these cases, and my gut instinct is that most states won't have very many of these cases. I don't know of a Texas case, for instance. Texas, however, has always had a definition of what it means to be independent and disinterested, and Delaware has one now. And I think when you hear that, when you hear, oh, there's a statutory definition, so you won't be fighting over that, and that will be very certain. These definitions hinge on words like material, right? Do you have a material relationship with the controller or the corporation or the other party? And it does confine it generally to a material relationship that is financial or familial or professional. But I think the cases that people got up in arms about, I'm not sure if they are fixed by having a definition that says you are independent as long as you don't have a material financial relationship. I think one case that people keep pointing to is where a director shared a jet with another person. And to be honest, I think if we went out and we surveyed people, I don't know if they would say that's a material relationship or not. I think a lot of that would depend on, do you share a jet with someone? I don't have a jet, so I don't know how close I would have to be with someone to share a jet with them, right? Is it a material relationship if you share a beach house or if you share, I don't know, a car? I'm not quite sure. And I'm not sure that we all have the same priors and instincts about what is a material relationship, even if we codify that in a statute.
That concludes our podcast episode. On behalf of the Council of Institutional Investors, I want to again thank my special guest, Christine Hurd, Senior Associate Dean for Academic Affairs, the Alan R. Bromberg Centennial Chair in Corporate Partnership, Business and Securities Law, and Professor of Law at the Southern Methodist University Dedman School of Law. If you have any questions or comments regarding this podcast, please feel free to contact me at Jeff, that's JEFF, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to the Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.